All right, this is a continuation of selling real property title opinions. We're going to talk about the case Board of Education of Minneapolis v. Hughes. This case provides an example of chain of title problems, in particular, a type of problem called the wild deed. All right, the facts of the case are as follows. Howardger executes a deed to Hughes. Howardger then conveys the lot to Duryea and Wilson. Duryea and Wilson convey the lot to the Board of Education. Then the board records its deed. Now, up until this point, Hughes' deed did not have his name on it. So Hugh here fills out the deed. He puts his name on it here. And then after he inserts the name, he then records it. Then, after that, DW records the deed as well. So, go ahead and add these numbers in. Perfect. So, the board, which is right here, they sued a quiet title, arguing that they were the bona fide purchaser, which recorded first. So Minnesota has a race notice statute. So the trial court agreed with the board. The Minnesota Supreme Court, though, in the case that we read, reversed, and it finds that Hughes, not the board, was the subsequent purchaser. This case is a bit confusing. So how is Hughes able to claim that he was a bona fide purchaser or the last bona fide purchaser, right? So remember, race notice jurisdiction, we have two. It is the last bona fide purchaser that records, right? So the Minnesota Supreme Court says that Hughes' deed does not become active until he puts his name on it, which is over here. And since he put his name on it as step 4, and the Board of Education took in step 3, that makes him the last bona fide purchaser. Now, most jurisdictions would have probably found that Hughes purchased here, right? But Minnesota rules that this is where he officially purchases. So had we just followed the first in time rule, it would have been the board that was the first in time because it received its interest here at point 3, whereas Hughes' interest, if we follow the Minnesota rule, wasn't valid until here. Let's try to go through some hypothetical problems to hopefully make a little bit more sense out of this. All right, so here's the following sequence of events. We're going to assume that all grantees here paid valuable consideration and that all deeds are validly created. All right, so we said that Horger conveyed to Hughes, who does not record, and then Horger then conveyed to D&W, who did not record. D&W conveyed to the board, then the board records, then Hughes records, and then we had DW record. All right. So assuming that Hughes received his interest immediately, all right, so that would be up here. Who holds the title, Hughes or the board? Well, in that case, the board would hold because the board was the first bona fide purchaser to record, and we're in a race notice jurisdiction. Now, what if we applied the Zimmer Rule? Well, under the Zimmer Rule, a subsequent purchaser is deemed to have recorded his conveyance only if all the prior conveyances in the chain of title were properly recorded, right? So, under the Zimmer Rule, the board's recording would only have been properly recorded if all prior conveyances had been properly recorded. And D&W didn't record until later. So under the Zimmer Rule, Hughes would win. Okay. What about if it was a notice jurisdiction? If it was a notice jurisdiction, then it wouldn't matter who recorded. The last bona fide purchaser who takes without notice would have superior title. And in that case, so if we're not looking at the recordings anymore, who was the last to take? Well, the board was. So in a notice jurisdiction, the board would have superior title. Let's do some more recording problems. All right, in the following situations, who owns Green Acre under a notice statute and a race notice statute? We're going to assume that all grantees pay valuable consideration. Okay. S conveys to B who does not record. Then S conveys to C who knows about S and B's deed. So immediately here, we should note that they are not a bona fide purchaser, right? Because they have knowledge. So C is not a bona fide purchaser. I would write that immediately. Okay. Then B records. We have a recording here. C records. Then C conveys to D. Then D records. All right. So let's say that there is a dispute between B and D. Who has superior title? Well, if it's a notice statute, then the last the last bona fide purchaser takes. Right? If it's in a purely notice statute state. So, who's the last bona fide purchaser? Well, it's a little bit of a trick question because there is no bona fide purchaser that qualifies. Why? Remember the shelter rule? So, C is not a bona fide purchaser, so that means D is not a bona fide purchaser. So it is B that takes because they were first in time. What about a race notice statute state? Well, because D is not a bona fide purchaser, then he doesn't meet the element of the race notice state, the notice, right? So because B recorded first also, B would be recorded first, so B gets it. Next problem. Again, C conveys to B, who does not record. Again, S conveys to C, who knows about. So C is not a bona fide purchaser. So again, we have C recording, B recording, then we have C conveying to D, and then C records. Okay. So again, the dispute is between B and D. Let's say we're in a notice jurisdiction. So here what we're going to ask is, could D have had proper notice based on what was filed, or constructive notice? So to do that, I would suggest redrawing out this conveyance as follows. All right, I would suggest creating a drawing like this, because D would, in a noticed state, D would be the one who owned Green Acre. When a title searcher searches, what they're going to do is they are going to go up the chain of title, starting from, so we have D here. So somebody that searches for D is going to look up. All right, we have title. They're going to go up all the way till they get to S. All right, because that's where the the conveyances, the records that we have stop. So they're going to stop here when they see S's. They'll then search under C's name to see if they could find anything under C's name. So they'd look from the SC, okay. But they're going to stop once they get here. They're not going to go all the way up here. So they wouldn't discover this conveyance over here. So SB, it is a late recorded deed. Because B recorded it late, it meant that they're not going to find this transfer. So let me try to explain it another way. All they are going to see in the records is this. Put another way, B records here. And so when D's title searcher searches, they're not going to see the conveyance. Since B's recording is late, D is going to have the superior title because they were the subsequent purchaser without notice. Now, let's say it's a race notice statute. Well, D still owns Greenacre. Why? Well, so first you look, was the notice, this is what it would be under the notice jurisdiction, right? And we said D would take. So then we're adding the additional element of the first to record. So was D um, he was the first bona fide purchaser to record. This late recording here is considered to be not a proper recording. All right, let's move on to the next problem. So again, here I'm going to draw it out. So S conveys to B, it does not record. B conveys to C, C records. Then S conveys to D. All right. Then D records. Then B records. All right. So let's start. If this was a notice jurisdiction, okay. The dispute is between C and D. So when D takes, all that's recorded is the conveyance from B to C. Whoever's doing the title search has no reason to look under B or C if it's a grantor index. They're just going to look under S. And if they look under S's name, they're not going to find any conveyances because nothing from S has been recorded. There is no way for the title searcher to know that there is this wild deed floating around here. So as a result, D is the subsequent bona fide purchaser and would gain priority over C. How about if this was a race notice jurisdiction? So we've already met the elements for notice. Now we would look to see who the subsequent bona fide purchaser that recorded was. Well, B and C's recording was not valid because it was improper, right? It was not done in a way that it would put a future purchaser on notice. Therefore, D would still uh, have a superior interest. Hypo 4. S conveys to B who does not record. S conveys to C who does not record. B records. C records. Again, let's try to think about whether C could have had notice of the transaction between S and B. What would be in the recorder's office if C went to go check? Well, if C went to go check, C would look to see what was under S's name. And when C goes to check, they would go to check here. At this point, there would be nothing in the chain of title that shows this transaction because that doesn't come until later. So C would get priority. They are a subsequent bona fide purchaser because they had no notice over here. And that's if we're in a notice state. Now, what if we're in a race and notice state? Well, C, we took care of the notice requirement. But in a race and notice state, there's an additional requirement, which is that it must be recorded first. So we go to see who recorded first and B recorded before C did. So B would take in a race and notice state. All right, last problem. So S conveys to B, who does not record. S conveys to C. C records. B records. Then C conveys to D, who knows about S and B's deed. Then D records. Say the dispute is between B and D. What if we are in a notice jurisdiction? Well, if we're in a notice jurisdiction, remember that shelter rule? Even though D had notice, right, C did not. And so under the shelter rule here, D is considered to be a subsequent bona fide purchaser because uh, of the shelter rule. C's priority over B transfers to D. And so, as such, D would take. Now, what if we were in a race and notice jurisdiction? Well, D would still own Greenacre for the same reason, because as you can see, they recorded their subsequent bona fide purchaser, because through the shelter rule, they take C's bona fide status, and they were the last to record. Okay, so what is sufficient notice? Well, the next case, we're on the General Income Sponsors of Iowa. The purpose of his inclusion really is just to demonstrate that a buyer is charged with having a notice of prior interest if they could have obtained the knowledge by investigating suspicious circumstances. And now the facts of the case did not, were not suspicious enough for the court to find that First National Bank and Manson State Bank should have investigated. Rob didn't even know at the point of the conveyance to First National Bank and Manson State Bank, the plaintiff, Rob, didn't even know that her house had been conveyed or had been taken from her um, due to a fraudulent inducement to invest. So how could First National Bank and Manson State Bank have had the notice to inspect when Rob herself didn't even know, right? The court also found that Rob's possession didn't put them on notice that she had any right to the property. And that's because her possession wasn't hostile possession. She uh, had the right to be there as somebody who leased the property, because if you remember the facts of the case, she deeded the property to these fraudulent investors, but then they offered that she could stay there and she paid rent to them. So her possession was seen not to be adverse or hostile. The last topic I'm going to quickly cover is title insurance. I'm going to go ahead and add it at the end of this video because we're only going to briefly talk about title insurance policies. The case in your reading is Riordan v. Lawyers Title Insurance Corporation. And I would like you to just read the case to get an understanding of what exactly title insurance is and what the title insurance company's duties are. So, as you can see, the title insurance um, created two obligations on the insurance company. The first was the duty to defend the title and the duty to indemnify. So, duty to defend and duty to indemnify. And so, the duty to defend refers to the company's duty to pay attorney's fees if there was a challenge to the title. And the duty to indemnify would be for the insurer to compensate the owner if there was a loss that occurred because of a defect in the title. Now, this case also shows you that although there are pretty broad protections with title insurance, there's also what are called exclusions, and those are general things that the title company will not cover. And then there are what's called exceptions, and exceptions are specific to the particular property. Also, the last thing to note about title insurance is the owner of the property usually purchases title insurance, and the lender, the person who gives the mortgage, purchases title insurance as well. You may remember from my discussion with Barbara Stewart that in North Carolina, the law doesn't require the owner to purchase title insurance, but she said she basically makes them purchase it. Most states, owners are required to purchase title insurance, and the lender purchases title insurance too. So the lender's title insurance protects their mortgage interest because they're going to want to foreclose on the property, take the property as collateral if payments are missed. And the owner's title insurance protects the owner. And that is it for the material that you need to know for Quiz 2.